Everyone, welcome to this discussion I'm going to have now with Professor Imogen Goold, who probably needs no introduction, but I'm going to give you a brief introduction anyway. Professor Goold is Professor of Medical Law at Oxford University, and she has a particular interest in how we regulate people's bodies. And it was that question and your writings on that, Imogen, that led me to contact you a few years ago. I don't know if you remember, but it was after I'd just finished work on the Tafida Rakib case, and you had just finished editing a book with, Jonathan Herring and Cressida Auckland, which I've got here. And I know you wrote a chapter on it, Parental Rights, Best Interests and Significant Harms. And that book, I think, was born out of the Charlie Gard case, amongst others. And it was something, and it remains something that's particularly interesting to me, around the concept of best interests, particularly for young children, how we regulate their bodies, if I can use such a term, and how much authority parents or those with parental responsibility should have, and how much they should take priority over others, for example, the courts. And so I'm going to start with that very, very easy question, if you don't mind, Imogen, which is, who do you think should have the final say in a child's medical treatment, and how have the courts decided that recently?
So I think at the end of the day, the court is the right organisation, is the right institution to have the final say. And the reason I think that is because partly they are to some degree objective. It doesn't mean, though, that just because people are emotional, they're making bad decisions. I think that's an easy thing to think, and actually that's not necessarily true. But I think sometimes when people are very invested and very distressed, it's quite difficult for them to be able to make the sort of dispassionate decisions that they might need to make, or to separate out their own desires from what is good for the child, whereas the court is more able to do that. I think the other thing about the court is the court has vast experience. I think people often forget that the courts see these decisions day in and day out, and so they build up a great deal of knowledge and experience about these decisions. So I think it is right to leave it with the courts ultimately, but with very considerable input from both families and from medical professionals.
Yeah, because I know, speaking as a parent, but also speaking to many parents, there is sometimes a frustration that courts should ever intervene. I mean, and the rule, as we know, is you should obviously, if there is a dispute about what's best, what's in the best interests of a child, and we'll talk about best interest perhaps in a bit, but where there is a dispute in a hospital, and let's say it would be a serious medical treatment decision to be made, or perhaps a decision about switching off some life-sustaining treatment machines, or perhaps a controversial medical treatment. And a parent or parents may well have a very firm view of that, and they might feel quite resentful, perhaps, that first of all a doctor or doctors would challenge that, and secondly that where they can't come to that agreement with mediation or any other kinds of discussions, there is a body that steps in. I suppose it comes to the question of whether parents have a right at all. I mean, I don't think they do. They have a duty, but how do you think, and why do you think courts should really be able to intervene?
So I think it's a really interesting question, and one of the ways into that question is to think, well, why does the fact that you give birth to or are the parent of a child give you any authority in relation to them at all? Which we often don't think about, but of course presumptively they do. And we afford parents lots of control, in a sense, lots of discretion. We don't tell them how to parent. We don't control the parenting very much. We only make certain demands. So children have to go to school. There's thresholds of things you must do to children, of course, and we look out for them through social services and so on. But largely we leave parenting to parents. And so I think parents rightly perceive themselves as ultimately responsible for the child. And we would want that, because of course that's how you end up having children who are well looked after. You want parents to want to look after their children, and of course parents do want to look after their children. Everybody loves their children and they're doing their level best. So presumptively that makes sense. But also, if we think about it, Doug Deacomer is someone from the US who's written about this. Why else do we leave it to parents, largely to parent? And it's a way in which we express a commitment to differences of values and commitment to differences of perspectives in a democratic society. As we leave parenting to individuals, and those individuals shape their family and their values and so on. So it's got that function as well. You can think about it in this broader way, in that sense. So as a starting point for thinking, that's really valuable. Why did we give it to them in the first place, and why don't we go in and micromanage parents? There's also the fact we can't micromanage parents. We can't step into people's homes, and in fact it's just simply not feasible. So you have to trust the parents, and actually on balance that's right, because when we look around, parents do a great job. Almost all parents are doing a great job, and if you know, sometimes they struggle, well, there's probably really good reasons and we help them. So if we start presumptively there, then when you think about it though as well, children are vulnerable individuals, and the state generally takes on responsibility, so via the court system, for looking after vulnerable individuals. There's lots of examples of that in the law, of course. And so what you see in these situations is a butting up of this good reasons for giving parents lots of discretion and authority against the concern that sometimes there's a vulnerable party, in this case a child, where they need support or they need decisions made. So once you're in that situation, then you've opened up the question of, well, who can do it? And there's good reasons to think that parents are a really good decision maker here. They know the child very well. They might have particular values that they want to bring to bear because those are their family values. So an example of that might be vegetarianism, right? That might be their family value, and so they might have views about that, or veganism, and that affects their decisions about certain things. So maybe vaccination might be an example of that. But then you also have the fact that sometimes parents don't have full knowledge. So not medics, they don't really know everything. And that's why you have doctors coming in and they make decisions, or at least they certainly give their opinion and they give very strong views, and they won't do things that they think are harming to the child. And that's right, that we shouldn't make doctors do things that they think go against their professional conscience. And so the minute you look at it like that, then you can see immediately there can be intractable conflicts. And in the face of that intractable conflict, someone's view has to trump. A decision has to be made. And if it's a situation where parents and medics can't agree, the only way through that is to either give parents trumping views or doctors trumping views. There's good reason not to do either of those things. And that's why it makes sense to have the court as effectively as a third party. So when you see it that way, it's better to see it as the court is actually an arbiter between the two parties, both of whom think what they want is best for the child, but they just disagree with what that looks like.
Mm. And looking at the cases, perhaps even since that book I mentioned, and you know, the Charlie Gard case, the Isaiah Hastrup, Alfie Evans, Tafida Rakib, do you think there has been, or there is a gradual shift, perhaps away from the paternalistic approach towards the individualistic approach to allowing or enabling parents to make those decisions? I mean, just looking at the decisions, and I know they're not a linear path, but I've seen more decisions siding with the parents' views than perhaps the medical views over the last few years, and I wonder if that's a trend or if that's just a coincidence.
I think it's always difficult to establish trends from the cases, because of course the only cases we have are when it gets to that stage that we get a decision. And of course there are lots and lots of these situations that never make it to court at all. And there's a range of reasons why they don't make it to court. Sometimes the parents acquiesce, sometimes the hospital acquiesces. So one party essentially gives ground. What we do know from the work of people like Giles Birchley and is that actually doctors go quite a long way down the line, sometimes past what they're really comfortable with, to make sure that they account for parents' views about things. And that's in some of his research that he's done from interviews with medics. We also know that medical teams work very closely with parents, and they think about best interests quite holistically. They're trying to get a family solution, and they do lots of work. So But I also think that these cases have fed back into that practice. So we certainly know that there are people who are caring for very sick children who are quite nervous, I think, about being the next Guard case or the next Evans case, because it's extremely stressful for them. That we know from the experience of those people who are the people caring for those children, they found it very, very difficult. And so I imagine that possibly is a trend, precisely because there might be more acquiescing on the part of hospitals, so they're not coming to court. In terms of the court, I think we've seen some quite challenging decisions of very particular facts. And they've been made more complex, of course, as you'll know, by external parties coming in. And I think that's the other thing that's probably causing this trend, is this shift in what can be done. So 20 years ago, you wouldn't have publicised in the same way. You wouldn't have had crowdfunding coming. You wouldn't have had protesting groups. You wouldn't have had hospitals from other jurisdictions coming in. And so I think from situations in the past, there just wasn't the context and the capacity for them to move in this direction. I think is a really good dimension that explains what I think you're seeing in this trend towards more parent-oriented decision making.
Well, you've just opened up about 10 cans of worms there. And I'm just trying to let me focus on one for a moment, which is that point you made about sort of outside influences. Pressure groups sometimes, or perhaps just financial backing, which enables some families to bring cases that others perhaps couldn't. Now I'll touch on, let me just focus on the beginning, the first bit. This is the pressure group, or the pressure. Do you think that, is there a concern then that there are some decisions that are being made that perhaps aren't necessarily in the child's best interests, but are being made, and I'm not talking about being made by the courts here, I'm talking about being made before they even get to the courts, because they don't get to the courts, because clinicians or trusts as a corporate body are just too fearful of the adverse attention and certainly with the Charlie Gard type cases, with the personal pressures that clinicians face when they're doing their day-to-day jobs.
So I think that's partly what Giles's research shows, is that that we do know that medical professionals are often they're making decisions about when to stop, say, life-sustaining treatment, or how many rounds of CPR, whatever it is. We definitely know that sometimes they go beyond the level of their comfort levels, or they're getting quite close to what they feel is beyond what they think is okay. Certainly anecdotally from lots of clinicians I've spoken to, they feel the same. They sometimes feel pressured to go a bit further than they think is actually good for the child, because of parental pressure. I think there's definitely in the background for some clinicians the concern that they might also be the next clinician who is subjected to the sort of pressure that they've seen their peers subjected to, and that's very stressful for them. So I think there's a cluster of things that are certainly happening. And plus, I think we have social media now that makes a difference to this, that people know that they can, that opposition and support for these parents and opposition to the medics can be gathered quite effectively. And that's what we saw with Gard and with Evans, is social media was a way in which they brought that to bear. So I think that's definitely is happening, that there are medics who are doing things that on balance, if they felt they were making a more free decision, they possibly wouldn't do.
And I suppose, how do you think we can row back from that to put the focus back on the child?
Well, I think one of the problems is that often I think the way medics were characterised in some of these cases was quite unfair. I think emotions were really heightened, relationships become very fraught in these situations. But what's really difficult for them is that the parents and their supporters can say whatever they like, essentially. They can speak freely, but the medics can't speak freely. And we saw that with Gard when some of the staff at Great Ormond Street wrote an anonymous letter trying to explain, look, we are trying our level best for Charlie. We're doing everything we can. We really care about him. But this is just the situation. But they can't come out and defend themselves because of confidentiality. So that's one problem. And I think the other problem, of course, is lots of this is really complicated. The medical treatment's really complicated. The data is difficult for anybody to understand. And so those two things create part of the problem. But I think the real problem is these cases created a lack of trust that medical professionals are doing their best for children. That I think that we saw this real erosion in belief that the doctors are actually doing their best. And I think that's one of the messages we really need to get across is nobody becomes a pediatric consultant. Nobody works in pediatric palliative care if they don't care about children. They absolutely do. And I think that was really lost because, of course, they can't come out in public and say, we are doing our best. It's just sometimes there's nothing we can do. Because you saw it a lot in the way people spoke about them publicly in public forums. It was really like a conspiracy theory. They really feel the doctors don't care. And that's just not true. And I think we really need to push back on that.
I completely agree. And I think one of the adverse effects of social media is that it not only does it put the pressure on the clinicians, I think it also puts pressure on the parents themselves. And obviously every parent is different, but some of them can get pushed along with that wave and start believing things that perhaps they didn't believe before. And then it becomes this adversarial process, which of course the family division and the court of protection for adults is not, and it's very much supposed to be a fact-finding exercise into an exercise whereby ultimately the judge has a discussion really with all the parties involved to try to find out ultimately what's best.
Yeah, absolutely. And I think that's it's really not obvious to the public what it's like in the court of protection. And it's just not adversarial at all. In fact, it's an incredibly compassionate space. Whenever one watches a hearing there, everybody in that room is trying their best to work out what is best for the child or the person in that situation, if it's in the family division. And they are thinking about it really, really carefully. They're not fighting at all. No. But I think, again, because we don't see that, it's not publicised, then people just aren't really aware that that's in fact what's happening, that no one isn't on that child's team. They just disagree about what's best for them.
Yeah. Can we move on now to that question, what is best for them? Because it is the ultimate question. And, even the concept of best interests is, it's very much enshrined in the Children Act, in UN conventions, in all kinds of areas of adult, in the Mental Capacity Act as well for adults. But how can we really know, we in this case, ultimately the judges, how can they know what is best for a very young child, particularly if it's something that is contrary to what the parents' view is?
Yeah, there's so much to unpack with that. So there might be a lot. I think there's a lot to say. Yeah, I think the first thing I always think about this is the very expression "best interests" immediately suggests there's a best answer. There's best, and then everything else is second best. And I think that's just not really a helpful way to think about it. So one of the ways that's now conceptualized in the medical literature and the philosophical literature is the concept of the zone of parental discretion. Now, the whole reason for that is, instead of saying there's one best option, it instead conceptualize it as there might be multiple good options, and within them you can make a choice, and they're equally reasonable. So that's the first thing I have to say, is that knowing what's best demands you make a hierarchy of good, and I'm not sure that's always possible. But I think that particularly with very young children, the really first difficult thing is that we can't know what's good for that child because we can't know them as an individual. So it really depends on what it is that we're talking about, and some things children don't know what's good for them. It's very difficult. You can't individualize it precisely because they haven't hit the cognitive level of having individual desires about things. If they're very small, they may not have personal interests yet. There's lots of things that make it a hugely difficult problem.
Yeah, and I should say, just for anyone who's watching or listening who may not know how these things are decided, certainly with adults, and it's the same question, what is in their best interest, and this is for adults who lack capacity to make the decisions for themselves. What the courts will do, or hopefully not the courts, what the doctors and early on will do is will try and put themselves in the position of that adult if they had the capacity to make the decision themselves and communicate that. And it's an impossible thing to do because you often don't know that person, but you might need to speak to others who do know them to find out a bit about them, etc. But you're asking, well, what would that person choose if they were in the room with me, able to communicate that? And of course, and as you say, for a very young child, firstly, they may not even be able to communicate because they may not have verbal ability. They may be really young, or say they're 5, 6 years old and they can speak, but they wouldn't really know what is right, because that's why you have parents or those with parental responsibility to help guide young children through life's myriad challenges. So taking that forward, let's say you have, well, let's use the example of Tafida Rakib, because it's something I know it was a controversial decision. I say controversial in that some people would agree with it, some people didn't agree with it. How do you think the court went through the process of trying to decide what that child, Tafida, would have valued? I should say also that case concerned a child whose parents were devout Muslims, and one of the questions in that case was whether that child would have or did have share the values of her parents and the religious beliefs of her parents. So how did the court in that case impose, if you can, impose a belief system on that child?
Yeah, so there's a really telling paragraph in the judgment in that case, and what you can see there is the court initially thinks in terms of harm, and it works through that, and it comes to the conclusion that they don't think on balance that continuing care for Tafida would be harming to her. And I think they think about it in a phased way. So once harm is off the table, then they think about other factors. They don't think about other factors balanced with the harm. They quite clearly in this one say it's not harming. It's not causing her pain. It's not causing her distress to stay being sustained. Now we can look at other factors to decide, given that, what should we do? And then they do engage with her spiritual beliefs. And that's because her family had argued essentially that she had religious beliefs. Now she was 5. And what's really, I think the thing that's caused some of the controversy with Rakib is the court suggests, or it accepts at least, that it is possible that she had religious views. And they talk about her getting a prayer mat and so on. So they're really saying that about her. And what I always think is difficult with that is that it's kind of presuming that she can hold committed religious belief, such that on the basis of that, it is all right then to continue her life to be sustained in a way that many people would find intolerable. And I think the difficulty and the thing that challenges people about Rakib is it's slightly hard to accept, because of course we don't accept that children of that age have committed beliefs about lots of other things. I mean, children who are 5 believe in all sorts of things that actually they will come to not believe in. And they will develop their views because they're just very, very young. When we know children of that age don't have much conception of what death means. We know children of that age still believe in Father Christmas. There's lots of beliefs that they have that they'll lose, and other beliefs that they will gain. And so they're very much in a flux. And so it's not that they couldn't hold religious views. It's just that it's you probably can't say it with the degree of certainty that was necessary in that case. Particularly, we even see research in older teens. So some research across through Auckland has done recently about, well, can even older teens hold committed religious beliefs? And the answer is no. So that it's not that I dispute that you could, it's just that the evidence suggests it's very difficult to say it's true. But then, of course, that whole decision turns on that. And I think that's why the court is slightly expressing a bit of being a bit uncomfortable with it, because they do say this is at the end of the spectrum.
Just looking at the Tafida Rakib case, and perhaps other cases, I wonder accepting that there may not, it's very difficult to extrapolate themes from any of these cases because every case is about an individual child. But I wonder if that was an example, and there are other examples where the zone of parental responsibility and decision making is sided with more, perhaps, than the harm threshold. Where, I mean, Rakib is a good example where someone apparently suffered no pain. Where there is a controversial or at least a challenged decision about what a child can believe, whether it's more accepted that that child would grow up with the same beliefs as their parent, perhaps.
Yeah, I mean, I think it's definitely a decision that you can explain through the concept of zone of parental discretion, and Deacon's views it's a similar kind of idea, that what I think they're saying there is, when harm is off the table, this is not a decision, if she's kept in sustaining care, that will harm her, then that means that there can now be a range of decisions that are all legitimate. And what that does is it makes space for the parent's view to then hold sway on the religious perspective. And I think that is what you're seeing there. And if you think about what Deacon is saying, he's saying, well, this is how we, in a democratic society, protect the fact that some people just have different views. Some people are atheists, some people are not. And so once it's not harming, if you think that harm is really important and it's off the table, then it's legitimate to leave space in there to decide it based on religious views. Now, here what they're doing is they're essentially saying she will grow up to share their views. She already was starting to, and so it's likely that will continue. But I think that was only possible because she wasn't going to be harmed. I think if they had found she would have been harmed, then I don't think they would have gone in that direction. And that's what we saw in cases like Evans.
Yeah.
That they didn't go in that direction for that reason, and that's where I think this idea of, well, why do we leave space for parents to have their decisions? And so if you thought that the decision Rakib was a good one, you would say, well, this is precisely the kind of decision that's given space to parents to have religious perspectives that other people don't share, and that's how we protect a pluralistic society.
Yeah, and using the examples of adults, say, where even if, let's take religion out of the equation for a moment, there will be cases where an adult or a child is in a state of unconsciousness where perhaps they don't endure any pain, but the medics might decide that there is no prospect of recovery, and they would argue that the treatment itself is futile. But there is an argument that you can impose a view on the patient that, because I'm not suffering any pain, the least I can do is be kept alive so that I don't want to make my loved ones suffer any pain. I wouldn't want them to suffer pain, and therefore my best interest is to be kept alive, because that's what I would want. Just pushing it a bit, but I suppose that might be a way to frame.
Well, I think that's it. Once harm is off the table, then a whole range of other things can come in and make the decision. One might be religion, one might be protecting family members. You might think it's about dignity. You might think it's about all sorts of things all come into play. And that's where it gets really difficult, of course, because that's where the differences of view come in as well. So most people would take the view, although not everybody, that if it's really harming, it's painful, if it's distressing to be kept alive and it's futile, then ending life-sustaining care might make sense. But once that's not true, then yes, lots of these things can come into play. But of course, best interest decisions are not supposed to account for other people's views. They're supposed to account for what is best for the individual person. But that's where the dispute comes in, because in a sense, you immediately start thinking about what would they want. And that's, of course, what we do with people who've lost capacity, who are adults. We do try to work out what's best for them, because we accept that people have different subjective views about what's good for them. So to work out what's good for that individual, you do need to think about what would they have wanted. And that's what you're trying to do for the child. But of course, the whole difference with child cases is you can't find that answer, because that answer never existed, because they're too young Yeah, and that's the conundrum that you face in every one of these cases.
And I suppose ultimately what you're doing then is looking at others within the family, elder siblings and parents, to say, well, what would they do? Because we're assuming that that child is going to grow up into some form of that sibling or a parent, and
Yeah.
that's problematic, I suppose, because
That's problematic because it's not necessarily accurate, isn't it? And so I think that the difficulty and the thing that we haven't really unpacked enough with children is that we can't deal with these cases in the way we do with best interests for adults, because some of the effectively the data that you need to answer that question doesn't exist. It's not that we can't find it, it simply has never existed. So you are necessarily then imposing an objective view of what is good, right? Somebody else's view of what is good. And the minute you're in that territory, then the question opens up, well, why does the court know better than a parent? And that's where you get that real clash, because then the court has to have a claim to authority that overrides parents.
Yeah. So if there is a dispute, or when there is a dispute, and let's say there are two very legitimate views on the table, and I suppose arguably there's always going to be two very legitimate views on the table, how can the courts and how do the courts decide what's best for that child?
So I think we see lots of different approaches in the judgments. You can see different factors coming in. What tends to happen is that you see vague references to things like dignity. And I think the reason that creeps in, of course, is because it's really hard to articulate what's wrong about keeping somebody on life-sustaining care once you don't think it's harming. And so I think what we're sort of seeing in the decisions at the moment is an inability to really unpack. I think people feel lots of discomfort about keeping somebody on life-sustaining care, even though, in fact, they've already accepted that it's not harming. And so I think the real solution here is, one, I think the courts need to do a lot more to unpack, well, what do we mean by harm? Do you mean physical distress? Do you mean psychological distress? What did that mean? So that in a case like Rakib, that needed a lot more unpacking, I think. And then what we need is more unpacking about, well, are we really committed then to saying, if it's not harming, that we really do let different families live their lives differently? And if that's true, then Rakib becomes a reasonable decision. But if you don't think that, or if you think there are still other things that are problematic that you wouldn't call harm, and dignity might be one of them, we need a lot more unpacking. Well, what does that look like as well? Because I think the problem comes in when you have vagueness, and then that is potentially a space in which the court cannot help but impose its views. And we see this in the work that Camelia Kong has done. You can see judges about best interest decision making for adults is, you can see courts really wrestling with this because it's really, really difficult.
And one area that we haven't really, we as in the community advocating on behalf of the trusts, and I'm not saying that you're on one side or the other, but from my perspective, we haven't really touched on resources as an argument. Rightly so, but with many of these cases, when we're looking at what's best for a child, and that word best sort of implies best possible care, and I didn't use the word available at the end of that sentence, but there's the nub, because there will be one child on a ward whose case for some reason isn't going to the courts, possibly because their parents aren't shouting very loudly, or there's just agreement, hopefully, between them and the clinicians, and another child whose parents are challenging something, or perhaps it's being challenged by other outside pressure. And possibly at the end of that case, depending on how it goes, that child, or actually during that case, that child will be accessing probably more resources, medical resources, and the resources of the court and other outside expert witnesses, etc., than others. And is that fair?
Well, I think that's another reason why sometimes it's right for the courts to make decisions, even though, of course, the court does not and should not make decisions based on resourcing. But and no one should be, but the reality is exactly as you described, that there are finite resources, and so sometimes these decisions are incredibly difficult, and that's the kind of decision as a parent you absolutely cannot make. I mean, I think it's just psychologically impossible for you as a parent to say, my child's taking up too much resource from another child, you'll only give them an extra couple of days or weeks, and I'll take those. Of course you would, because that's the nature of being a parent. I think that's part of the difficulty here, is we can't talk about resources, and yet resources are talked about. They're just not talked about in individual decisions. I'm just not sure that the courts are the space in which to have that discussion, because they are rightly prevented from making resource-based decisions, because they're not well placed to make resourcing decisions. And it might just be that this is a conversation that we need to have much more publicly about this. And I think people are often shocked by how much the care of one child takes. And ultimately, we just try to pretend that we're not making resourcing decisions, but they are being made. And I think you're right. It is really problematic that some children do better than others, purely because of how things have played out in terms of how their parents have advocated for them, how the trust has managed things, and that can't be right.
Mm. And it's with adults as well. I mean, there's a recent case that I was involved in called Jordan Took, involving an adult, sure you know, who has advanced kidney disease, and the court took an amazing decision, really, and the trusts involved in that case were very supportive of that and pulled out all the stops to gather huge amounts of resources to enable that person to receive dialysis treatment and hopefully ultimately transplant surgery. I'm mentioning his name because it's in the public domain and there wasn't reporting restrictions in place in that case. But that's, whether that would have happened without the courts, I don't know. But you're right, courts don't and they can't make a decision based on that. Does it lead to health inequalities, do you think?
Like, absolutely leads to inequalities, but I think the solution doesn't lie in the courts. I think the courts are focused on one question, and rightly, they're asked what is best for this person. I think that the difficulty is that there's not this joined up interaction between the court decision making and resourcing decision making. That the minute the court makes this isolated best interest decision, that has resource implications. But because we don't have the background structures to properly manage that, then we just haven't dealt with that problem, and it's a structural problem. And the answer doesn't lie in the courts working it into best interest in an ad hoc way, because that would be wrong as well. The whole problem is that resourcing is a big question that affects lots of people, and some actually dealing with that head on to say there have to be boundaries about what the courts can do. Or when they say best interest, it's best interest against this defined constrained background. Might be the answer, but that takes a lot of working through. But at the moment, it does create exactly this problem. And we see it across the board. We see it in SEN cases as well. The parents who go to tribunal get more than the parents who can't. And that across the board is really problematic, to have one child getting lots and lots and other children getting really nothing at all. Can't really be fair. But I think we haven't really addressed that at all. And it needs to be fully opened up and thought about.
And does that, opening up and thinking about it, does that potentially involve a different system of making these decisions perhaps without courts involvement, perhaps with a different body looking at all of these cases?
I think it's about thinking. I don't think the court should bring resourcing into their best interest decision. I think it's about, possibly the answer is courts make a best interest decision, but then the way in which a trust has to action that best interest decision has to be against the background resourcing constraints that they have, and that we need to develop rules for how they then navigate that if it puts them in an impossible position. Because of course that is what happens. If it does put them in an impossible position, then they now have to find resources that they don't have. And then it's tried to say that the NHS is cash strapped. And so it can't be a good outcome to put trust in a position that they just can't do what they're being told to do. And so I think that's what it needs, is some direction about what is the background against which they have to put into practice these best interest decisions. I also think we need a public conversation about it. I think that people need to have more of a sense of this is the implication of what happens when we do this. Now, we might think that implication is okay, but I don't think we've really engaged in it. Certainly, in all the public discourse around these high-profile cases, there's very little discussion about what does it mean when we push for one child to have this much. What happens to all the other children whose names aren't in the press, who aren't being shouted about, but it is having an impact on them that needs to be thought about.
Yeah, and taking that further, I think we may not know the name of the individual, but when there are only so many numbers of pediatric intensive care beds, and so when one bed is being utilised by one child, arguably for too long, and I say arguably because that's often the subject of these cases, there is another child potentially in the wings who hasn't got a bed.
Yeah.
At the moment, I'm hopeful, and I understand that's not the case, and the NHS will move their resources around to ensure that there will always be a bed for that other child. But again, with times of pandemic, that may not be so easy.
Yeah, and it's going to become progressively more difficult.
Yeah.
Because the NHS is under constant pressure, growing pressure. And I think also we see, and this is another thing about the public conversation we need to have, is that in these situations, that's exactly what medical professionals in the NHS do, is they expand and they find ways to make this work. But that is an incredible burden on them. And I think we just don't say enough about the fact that they are managing that burden all of the time while trying to give all of these children the very best of their care. And I think that's really been lost in some of the discussion around these cases, that I think we've seen a couple of statements from medics really saying we are doing our best. And I think we really need some public recognition of that.
Absolutely.
Well, I think, in some ways what we see in these cases is parents going out and absolutely fighting for their children. That's how they contact these people. That's how they find them. And that's a really wonderful aspect of parenting, that parents do that. And it is a modern phenomenon because you wouldn't have been able to do it 20 years ago. I think in some ways it might be a fantastic thing. They find a treatment and it's great. But I think the problem happens when we don't respect that the treating hospital here has taken a view on that and has made a decision, so this treatment just won't work. And I think that's what we've seen in some of these cases, is the idea that the originating hospital hasn't really taken seriously the option of these alternative treatments. But of course, in GUARD, they absolutely did. They did listen, they did try, but they took a clinical decision as things progressed not to pursue that. And I think that was really lost in the explanation of what had happened in GUARD. And again, this sort of loops back to my point that I keep making, is that we need to trust medical professionals in large part. That they do want the best for the child. So if the parent finds an overseas expert who says, I think there's this treatment, and the treating hospital talks to them, they say it's just not going to work, well, then we need to respect that. I do think if there are situations like in Rakib where the family has very different views and we don't think it's harming, and we do find another, as they said in that case, responsible treating team, well, then moving your child to that other responsible treating team is okay. But the really key thing was there that the court in that case did try to evaluate them and say, this is moving them to someone responsible. I think that's where some of our focus needs to be on. It's not okay to let a vulnerable child be taken out of the country to be given unsupported, unclear, unverified treatment. That would be clearly wrong. And so I think it feeds into the best interest question, is the treatment, the alternative treatment, one that's being offered responsibly?
Yeah, but with Rakib, they weren't offering any alternative treatment. They were just offering the same treatment, but they were prepared to provide it for a longer time, I think. But there may be cases where that treatment, which might improve the child's outcome, is simply not available in this country. Either the resources aren't there, or perhaps the technology isn't, or the expertise isn't there. But it is available, say, in California, or somewhere, or China, and for those cases, what's your view of how much the court should enable that child to be, if it's safe, be taken abroad?
Well, I think the thing is with those cases, if say there's a treatment in California, it's not available on the NHS and the parents have the resources to take the child there, the reason those sorts of ones probably don't come to the courts is because the treating team in this country would have said, yes, that's fine, it's non-contentious. I think the contentious ones are, as you say, Rakhi, where really what's happening there is not different treatment, but longer sustaining, where there's disagreement about whether being sustained in that condition is actually okay and is best. And that has to remain a best interest decision, which it was in cases like Evans and Gard in some ways, where it's a really experimental treatment. I think that's the really tricky question. And that's where parental perspectives, I think, do come into play. If it is a genuinely experimental treatment where you think there's a possible chance, but the chance is very low, that's the real nub of it, is that that's really subjective about what risks are worth taking relative to which harms. And there, I think parental views really ought to have, in my opinion, quite a strong weight, like quite a heavy weight there, unless it's really, really harming. That because for most of us as well, if we thought, what would I do? I would take a 1 in a million chance if it was that or nothing. It's quite sensible. The really difficult bit is how much pain and suffering would I be prepared to go through? And that's where these things get really tricky. But I think we need to then try to imagine what would we have tolerated possibly for the hopes of getting better, and what would just getting better look like. I think that's the other thing that's often not talked about as well, is what are the outcomes of these treatments? So it can't just be small gain for very big loss. I think it has to be openly discussed. But we do have to take account of the fact that lots of us would probably take a 1 in a million shot if it was that or nothing. And we shouldn't say immediately that we shouldn't do the same for a child if the parent thinks it's worth it.
And what worth it is the massive $1 million question, isn't it? Because worth it could mean being profoundly brain damaged, brain injured. But then even that, who's to say? Who are we to say that that's not a worthwhile life for that child? But as you say, the flip side might be considerable pain, and how much pain should that child tolerate, or would they tolerate if they had the ability to make that decision for themselves? And we don't know.
And that's the problem with all of these cases, is it's unknowable. It's just simply unknowable. And I think what's also difficult as well is it's unknowable for parents to know what that would look like at the beginning of that journey as well. And that's the bit I don't have an answer to that. I mean, that's the really hard bit, is knowing the unknowable. I can know what chances I think are worth it, and they're probably different to your chances. But with a child at that age, it's just really difficult. And so, erring on the side of not harming seems to be a good heuristic. It's not the whole of it, though.
Yeah. Well, I mean, I would finish now by saying my view is that we don't have a perfect system, but I think one of the exemplars of our civilized society is the court of protection and the family division, and the decisions and the ability for a court to step in on these really challenging cases. That not every country has this system, but also the resources behind the system, whereby experts and clinicians will spend hours and hours, and lawyers will spend hours and hours over these really difficult cases on behalf of the child, to make sure ultimately the judge has all the evidence before him or her to make that impossible decision, which they make on a daily basis.
Yeah, and I think it's a court that really, I don't think the public are particularly well aware of, that actually it does this work in the way in which it does it. And it does it with tremendous compassion, and a real commitment to trying to get it right, in the face of really quite extraordinary difficulty a lot of the time. And every decision I read, every decision I watch being handed down, the really key thing is the level of compassion and thought that goes into those decisions. And I think as a community, we really need to notice that and celebrate that much more than we currently do.
Thank you. Well, Imogen, it's been a real pleasure to talk to you about, I mean, I could go on for hours. I'm sure we could wax lyrical about all kinds of things in relation to this, and it's just wonderful to hear your thoughts on this really challenging and evolving area. So thank you.
Thanks for having me. It's been great to chat.